I'm Doug Thornton. I'm an attorney. I've been practicing law for 30 years, in Frederick for about 29. My office is in the Nymeo headquarters. I'm going to give you a presentation on how to unlock the myths of estate planning. The first thing we talk about in estate planning is we look at who's involved in the process of an estate plan. And one is the client, and that would be you. You all would be the client. We're preparing documents for you. We also look at what you're going to do during your lifetime. There's some estate planning that you need to have in place while you're alive, believe it or not. So it's not really estate planning, but it's what we call pre-death planning. And those are what we call lifetime appointments. So let's talk about who's impacted. Sometimes you don't want your children to receive all your money when they're maybe 18 or 20 or even 21, because maybe they're not going to be financially responsible with their money, right? So if you have something in place, you can protect them. You can protect them from themselves, really, by having some control over how you're going to disperse the money to them. So if you die without a will, your family will inherit the property if you're married. Half of it will go to your spouse and the other half will go to your children. This is if you pass away without a will. It is a legal fiction that your spouse can sign for you. So if you're married and you're alive, your spouse can't sign legal documents for you. That is not true. A lot of people think that's true. If you die without a will and you're not married, let's say you're not married, and you have no spouse, you have no children, who gets your property? Your parents would get your property if you die without a will in those circumstances. So let's talk about if you don't have any real immediate family at all, okay? So you have no parents, you have no siblings, you have no grandparents. We get into what I call the laughing heirs. They're in the middle. Those are the heirs you don't really know, and they're laughing all the way to the bank when they get your money, okay? They would be grandparents, other children, great-grandparents, and ultimately, maybe the state of Maryland would receive the money. Sometimes if you have no heirs at all, then the property will do what we call it as cheat, which is where it goes to the state of Maryland, but that would be if you have no heirs at all. You have a choice. That's what I focus on. Is this the real mantra of this presentation is have planning in place now so that you can make these decisions for the future. You can choose so that your laughing heirs aren't the ones who are going to inherit your property, but you can choose in your will who you want to be your beneficiaries. You can also choose who you want to handle your estate, and that again is what we call your personal representative. You may have heard the term executor, maybe. Same idea, we just call them a personal representative in Maryland, but it's really an executor. You can choose who you want to be in charge of your estate, and that's what we call your personal representative. And if you die without a will, believe it or not, one of your creditors can become your personal representative. Your creditor can come in and take charge of your estate and manage it and distribute it. And that happens quite often when people die with a mortgage and the mortgage doesn't get paid when they die, they don't have a will. The mortgage lender comes in and tries to be appointed as the personal representative. And why do you think they do that? Because then they can take charge of the property. It's easier for them to sell it than it is to foreclose on it. So they try to get control. So let's talk about what you own and what's part of your estate. So what assets do you own or need to disperse upon your death? We look at personal property you might own, like furniture, furnishings, cars, antiques, collectibles. We look at your bank accounts. You might have an investment account somewhere. You might even own a business, right? Or you own some real property, have an interest in real estate. We look at where the property is located and we talk about how it's titled. When is also the big critical planning tool. Because you want to do it during your lifetime, right? Because after you're gone, if you're deceased, there really is no planning that you can do. There's no post-death planning that can take place. So the documents you need during your lifetime are the durable general power of attorney, or sometimes we just call that a power of attorney, okay? A healthcare power of attorney, and in Maryland we call that an advance directive. And these two documents are what I'll call the legal seatbelts. They help you while you're alive, and these are critical documents. They're almost more important than a will, believe it or not. The durable general power of attorney covers financial matters, and it allows the person you appoint to make financial decisions for you if you're not able to do so. If you pass away, that's what we're headed into now, is how to distribute your assets upon your death. So there's numerous ways to transfer. One way is to title the assets in the name of your heirs. So that might not be the best decision for anybody to make, because when you title assets in the name of somebody else, they own them with you. They are their assets equally as much as they are your asset. Another way, number two, there is a direct transfer on death, and that's something we call like a pay on death or a payable on death beneficiary designation. That's what you do with your life insurance policies. You name a beneficiary. Maryland has a statute that allows you to make distributions on death for investment accounts and bank accounts. So that's one way to do it, the direct transfer on death. You can also have a will. We call that legally, the term is a last will and testament. So you can have a will in place and that distributes your assets on death. And then you can also have a trust. That's number 4. We also want to talk about health issues, who can consent for treatment for you. What we want you to encourage you to have are legal documents in place now during your lifetime so they can control your assets while you're alive, versus the need for your family to hire legal services or pay attorneys to pay for legal services.